Welcome to Trust Me, It's Complicated, Decoding Estate Planning, Probate, and Trusts with attorney John Marshall.
Hello and welcome to Trust Me, It's Complicated, Decoding Estate Planning, Probate, and Trusts with attorney John Marshall, founder of Marshall Law. I am your host, Kevin Rosenquist, and today's episode is Power of Attorney Unplugged, Demystifying Important Legal Tools. John, good to see you. Thanks for being here.
Oh, thank you, Kevin. Appreciate the doing this again.
Yeah, absolutely. So tell me what some common misconceptions or mistakes people have about powers of attorney that might lead to legal challenges or misunderstandings.
So power of attorney is a very powerful document. And sometimes people are given that power and they assume, well, I can do whatever I want. And the problem is, no, you can't. You are entrusted with the power of the principal, the person who gave you the power, but you have to use it for their benefit. Furthermore, as agent, you are a fiduciary, meaning that you can be held liable for the actions that you take if they are not in the best interest of the principal. The other issue is that, in doing what is in the principal's best interest, you got to make sure too that you're not doing something that's a conflict of interest, that you are putting the principal's interests first. When you violate those principles, when you violate your fiduciary duties, that's typically where we see lawsuits happen, disagreements in family begin to erupt, and the real problems begin to enter into that situation.
Gotcha. Okay. And can you kind of go through the primary types that individuals should be aware of?
So there are various types of powers of attorney, and sometimes one may bleed into the other. So first of all, you have to understand there's a difference between a power of attorney and a durable power of attorney. A power of attorney ends when the principal, the person who's giving the power of attorney, becomes incapacitated. So if I'm the principal and I've signed a power of attorney giving my wife authority to act on my behalf, I'm the principal, she's the agent, but a regular power of attorney, I become incompetent, power of attorney is null and void. A durable power of attorney means that even if I become incapacitated or incompetent, the power of attorney is still valid. That's actually most of the time when we need a power of attorney. It's
Sure.
when that principal's become incapacitated. But there's also general, which means very broad powers to do pretty much everything, and limited powers. So maybe I'm giving a limited power of attorney to someone to handle a real estate transaction for me because I'll be out of the country, or maybe I'll be addressing some other issue and I need someone to fill in for me in that moment for that limited purpose. Those limited powers can also be limited in time. It ends on such and such a date, things like that. Those are used sparingly. Usually if we have a very specific circumstance that we need someone else to interact on our behalf, but we don't want that going on in perpetuity. There are military powers of appointment or powers of attorney under Florida law. Those are actually also a creation of federal law. And those say certain powers come into effect if a person is deployed. And those are very important because in Florida, we have a lot of military bases here and a lot of active duty personnel. The one thing that is not technically a power of attorney, but it's something that people should be aware of, is a designation of healthcare surrogate. In some states, a medical power of attorney is what it's called. In Florida, it actually falls under a different statute, but people oftentimes confuse that with a power of attorney. And then finally, there are things called springing powers. These are powers of attorney that come into effect if only certain circumstances occur. While those are recognized in many other states, Florida has abolished those. We cannot tie a power of attorney to a future event. Like if I become incapacitated, this comes into being. You give a power, it is effective immediately. We cannot condition it on a future event, although we can condition its termination on a future event or time period.
Okay, interesting. So with the durable versus general power of attorney, are there many differences, or is it just the one difference that you mentioned before about being incapacitated?
So, a durable versus non-durable or just a regular power of attorney, it's purely related to capacity. In my practice, probably 90 to 95% of all powers of attorney I draft are durable powers of attorney, and usually durable general powers of attorney, because what we're trying to do is enable for another person to fill in for you at any time that you are incapacitated. Granted, they can use it while you're alive. My financial advisors know, don't call John during the workday. I'm not going to answer the phone. In fact, my phone is silenced during the workday. They know, call my wife. If anything needs to be signed, Patty can sign it. But I've given her that authority. But in that power of attorney, I've also named backups. Because if my wife were to become incapacitated or predecease me, and I was also incapacitated, now I have successors who can fill in without having to worry about what if and what happens then. Because if we don't have that power and I'm incapacitated, now we have to turn to the courts to appoint a guardian. And I always tell people the only winner in a guardianship is the attorney, because we make a lot of money doing that. And quite frankly, it's not a good court case for the person that's incapacitated or for the family. So if we can avoid that through the use of a power of attorney, we want to do that.
What is the role of the agent under a power of attorney, and what responsibilities do they take on when appointed?
So they act in the place of the principal. So again, if I need something done at the bank, but I'm busy, my agent can go to the bank and handle it on my behalf. Think of it almost in terms of a manager of a business. The business may be owned by another person, but that manager has been granted authority to transact business on behalf of that business. So, their responsibility, though, is to manage those actions or manage, certain assets on behalf of the principal. So if the principal is incapacitated and we need to apply for some type of Medicaid benefit, we want to make sure that that agent is empowered to do that. If they need to have a contract signed, we want to make sure they do that. And that's the interesting thing is when my father-in-law needed rehab care, my wife was able, as his agent, to sign the contract on his behalf and said, she signed it, Charles Smith by Patty Marshall as agent. And that was an important way to sign, because what it said is he's signing it. I'm filling in, but it's binding on him. But me as the agent, I'm not responsible for the contract here. If he doesn't pay it, or if there are insufficient funds or whatever, you can't come after me. Mm-hmm. But he was in the hospital. He couldn't go to the rehab facility and sign. So she was able to get that contract, bind him to the contract. He's legally responsible. She is not personally responsible, but now he was going to get the care that he needed.
Okay, that makes sense. That makes sense to me. So for anyone listening who might want to, get on this power of attorney, make sure that they have documents that are valid and enforceable, what kind of tips do you have for them? What steps should they take to make sure that they're doing it the correct way?
Well, this is sounding like, hey, I'm just trying to benefit me, but it's true. Hire a good attorney, an attorney who does this area of law. Right now, I am involved in a guardianship, and the whole purpose of this guardianship was to address the fact that the gentleman who was the principal went to an attorney who said, oh yeah, I can do a power of attorney. The power of attorney is old in the sense that it has language that goes back to a statute that existed prior to the current statutes. So it doesn't reflect current law, and it was not properly executed in conformity with the law. So now, for a cheap price, he got a power of attorney that he did not know was ineffective until when it was needed. And at that point in time, he's incapacitated, so now we're in a guardianship. All of this could have been avoided if he hadn't gone to an attorney who says, I'll do anything that walks in the door, or to an attorney like me that says, yeah, these are the areas of law I practice: estate planning, probate, guardianship, elder law, and that's it. So you want to use an attorney who does this area of law. And the other thing is you want to avoid the self-help forms. Again, I've had a self-help power of attorney presented to me this week, and they found it online, and the guy signed it. And I looked at it and I go, yeah, I can't accept this because it's missing some very critical terms that are required under Florida law. And the law or jurisdiction that this power of attorney was created for, I have no idea. It could be one of any number of jurisdictions. There's only 50 states. So that's kind of the issue is when you find documents online, you don't know where they're from.
No.
So hire,
especially now with AI, right? Like you don't know who's writing them.
Well, and that is a big issue. I use AI in my practice, but AI is a tool. Right. It is not a replacement, and it is not legal counsel.
It's not a lawyer.
Exactly. Yeah. And I use AI in my legal research, but I am using it from the standpoint that I know how to use it as a tool. But when you go on to Chat GPT or something like that, what people don't realize is it's scouring the internet and it's scouring sources, and it may be pulling data from places that are not good sources or
Right.
may not be applicable to the state that you're in. And generally, AI is just not at that point where it can differentiate between some of those issues.
Yeah, my parents did an online or like a legal Zoom type thing for their estate plan, and I'm like, I've been telling them like, I talk to lawyers a lot, for what I do for a living, and I really don't think that's a good idea. I think you should go see somebody, but they're being stubborn. So hopefully we don't
Just
have
tell them
issues.
that the attorney you spoke to says he loves LegalZoom and law, or law docs and all that, because he will make more money cleaning up the mess than if he had did it right the first time.
Okay, maybe that'll
And
be
unfortunately, that is true.
that's the truth. Yeah.
So and that's, as an attorney, it's my duty to give people the best advice and what's in their best interest. And so if we're trying to avoid problems, we will take those steps to avoid it, even if that means I'm avoiding a problem I may have made more money on addressing later. But that's not in my best interest, it's in my client's best interest. Whereas those online programs, they don't have an interest like that.
No, of course not.
So they're not programmed from that standpoint.
And it's like one of those things too. It's like if you can do something like that for $39.99, you should probably run away. It's probably not your best option.
I guarantee you. So, but hey, you know what? People are going to do their own thing, and
Yep.
like I said, it's going to be in front of an attorney either when you do it or later on when it's being addressed after the fact.
Absolutely.
So one way or the other, it's a legal issue, and but if you see an attorney up front, a good attorney will always say, "Let's find what's in your best interest and your family's best interest, so that we don't create problems that cost a lot of money to fix. We can actually head off problems that we then later don't have to address, or when we do address them, it's going to be a minimal cost."
And not just the money, right? The time, the chaos that people have to deal with, like your kids or whoever the people that are handling everything afterwards have to try to deal with. It just becomes way messier.
Yeah, and it's funny, people ask me if I do family law, and I say, well, I don't do divorces or anything like that, but I practice family law every day because this area of law that I'm in, it's all family. And going back to the power of attorney, you appoint someone to be agent under the power of attorney who doesn't understand their duties, abuses the authority that they're given and things like that. It's now brother and sister fighting each other, brother and brother, aunt and uncle. It's family. And quite honestly, we want to be very selective about who we give the power of attorney to. We don't want to give it to someone who has a history of, mismanagement of funds. If I have a client and they say, well, I really have to name my oldest son, and I say, does he have a history of bad money management? Well, he's got 3 bankruptcies and he's currently behind on child support, but if I don't name him, he'll be offended. Well, I can tell you right now, would you hand your money to anyone that meets that criteria if they weren't your son?
Right.
It's not to say that you don't love your son, but we're now managing your retirement assets. We're now managing your money. So, you have to evaluate who you give this power to, and it needs to be somebody who's trustworthy, who understands their responsibilities, and even somebody who will say, hey, when faced with a situation that, I need guidance on, I'll talk to an attorney so I do it right, so that I'm not causing problems. I'm actually preventing problems from springing up.
Right. That's a really good way to put it, for sure. All right. So you mentioned guardianships. Can you kind of unpack that a little bit? So the potential consequences of not having a power of attorney in place can get complicated. Can you talk a little bit more about that?
Yeah, so anytime that we have a situation where a person has to have their assets managed because they become incapacitated. I just spent all yesterday at an Alzheimer's conference, and I'm wearing a wristband here because I'm part of the Tri-County Executive Committee for the upcoming Alzheimer's Walk. It's something that we're passionate about. And in my practice, we want people to execute a power of attorney up front, because if you don't have it and you become incapacitated, let's say you have Alzheimer's, we now have to go to the court and get the court to appoint someone to fill the role of a guardian. And the court will appoint who they believe is best suited to it. And it may not be the person you chose. The court case I'm involved in now, the gentleman did not want his wife being the agent under his power of attorney. It's not that he didn't love her. His will leaves everything to her. But the reason was he didn't think that she would be up to the task of managing his assets when he became incapacitated, because he managed all the assets during the marriage. And when his power of attorney was deemed to be invalid, she's now in there trying to be appointed when the whole purpose of that was he didn't want her to be appointed.
Right.
And it's not common that happens between spouses, but it does. But you may have a child that you say, yeah, I haven't had any dealings with this child for 10, 15 years, and I don't want them involved in my life. But now they come into the court, and the court doesn't know the backstory. The court isn't, a part of any of those conversations. And on top of that, the court can only look at the facts as presented to them right there. And if the judge goes, yeah, you've not had contact with this child for 10, 15 years, but they're a financial advisor and they have a background in this and whatever, now you're putting it in the hands of a judge who doesn't know the family dynamics.
Right.
So take that power back. Execute a proper power of attorney. Don't put your family in the situation where they are now in a court fighting with each other, and a judge that you don't know, maybe didn't even vote for, is now deciding how your estate is going to be handled while you are incapacitated.
Mm-hmm. Yeah, that's definitely something you don't want. So as we wrap up here, when someone sits down and with you and says, okay, we want to do this, we got to decide on a power of attorney, what kind of advice do you give? What kind of questions do you ask? Obviously it's up to them to pick it, but what are your tips?
So the main things that we want to talk about is, who do you want to appoint? Do they understand the role that they're going to be taking on? Do they have the skills? Like I said, you can have a child who's the best, nicest person in the world, but if they can't balance a checkbook, if they don't understand or have the ability to take direction from professionals, then they probably shouldn't be in that role, and that's not to say that you don't love them, but okay, don't appoint them.
Right.
But, at the same time, maybe that child is a nurse or a doctor. And so maybe they're not really good at the money management, but maybe they would be really good at making your healthcare decisions if you're incapacitated. So it's okay to have people in two different roles.
Good point.
But again, we want to talk about those, and we want to be honest with ourselves. And that's the one thing I want clients to understand is be honest with yourself and the circumstances, because when we really need this power exercised is at a time when you're going to be at your most vulnerable.
Right.
And I don't want to take a gamble on somebody doing things right if they don't have a track history of it, or if you don't really know that they're going to be able to separate their personal feelings from what's in your best interest.
Mm-hmm.
And that's really a key issue there is, empower the person, but it has to be somebody that you trust and that will do the job and do it well. And then secondly, have backups. Because as much as we would like to say, this is the person I'm going to give it to, I cannot predict the future. Right. So my power of attorney names my wife. If my wife's not available, it names my father, and then names my mother. Now, as we get older, those will probably change. My parents are, in their late 70s. And so as they get older, I'm going to have to pull them off, because I don't know that it would be fair if something happened to my wife to burden them with managing things on my behalf if I was, incapacitated, because they're getting older. So maybe I add my sister, maybe my brother-in-law, and again, we want to revisit these people over time. We don't want a power of attorney to become stale. And the fact that, as circumstances change, it's not updated to reflect, the family dynamics.
Right.
And that is a topic that people will sometimes bring in a power of attorney, and I'll say, hey, do you still want Joe as your agent? And they're like, I haven't talked to Joe in 10 years. Is my neighbor up in Ohio, but I haven't talked to him in 10 years. And I'm like, well, we probably don't want to put him in charge of anything related to your estate, So again, you constantly, I always tell people, pull your estate planning documents out at least once a year and read them and say, does this still meet my needs? Is this still relevant to where I am?
Right.
And that's especially true for the power of attorney.
Yeah, definitely. Definitely. Great tips all around. All right. Well, thanks for tuning in to Trust Me, It's Complicated, Decoding Estate Planning, Probate, and Trusts with attorney John Marshall. To connect with John and the team, head to marshallawpa.com, and don't forget to like and subscribe to our channel. John, always great to talk with you. Thanks so much for being here.
Great seeing you. I'll talk to you again soon.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.